Good afternoon and welcome to this webinar on cross-border estates. My name is Kerry Parsons and I work in the private wealth and inheritance team at Harrington Carmichael. I am a senior solicitor within that team. Harrington Carmichael solicitors are a full service law firm. We now have over 180 staff. We're predominantly based out of Farnborough, but we also have satellite offices in Reading, Ascot and London. We cover most aspects of law to include corporate, commercial, immigration, litigation, real estate, conveyancing, family, and private wealth and inheritance. The private wealth and inheritance team itself cover a broad range of different areas to include wills, powers of attorney, court of protection work, estate administration, trusts and estate planning. This webinar today is going to cover a number of things, but predominantly we're looking at cross-border estate administration. So we're going to look at what is a cross-border estate and what do we mean by that. We are going to look at domicile, succession, inheritance tax, which are three very important subjects within this area. We're going to look at a few things to do with administering an estate with a cross-border aspect, and then we're going to look at a few best practice points at the end. This is quite a complex area, so we're only going to kind of touch on some of the basics in this webinar. So what is meant by a cross-border estate? So a cross-border estate is essentially an estate where an individual has a collection of assets which are based perhaps here as well as overseas, or an estate where somebody perhaps was born here but has assets overseas or a connection overseas. You'll see on the slide I've put in a few examples of what might be deemed a cross-border estate. So perhaps an estate where the deceased individual had a property in more than one country, so they might well own assets here, but they may have a holiday home in somewhere like Spain, which they use in the summer. So that would be a cross-border estate. We also sometimes get individuals who may have business interests overseas or investments overseas, perhaps for tax reasons. And then we also deal with estates where perhaps somebody was born here, but then they moved overseas, but still have assets here, or the other way around, where somebody was perhaps born overseas and has spent a lot of their life overseas, but they now live in the UK. They've got assets here as well as abroad. So they're just a few different examples. Where we do deal with estates with a cross-border aspect, it's important to consider the inheritance tax rules and succession rules here, but it's also important to consider inheritance tax or whatever the equivalent is in the other countries in which they have assets. Obviously, with different countries having different tax regimes, it can be quite complex sort of to navigate and deal with an estate which has assets in multiple jurisdictions. So considerations when dealing with a cross-border estate, which I've already touched on, we need to look at domicile, succession, and inheritance tax, or death duty as some countries call it. So just to start with domicile, domicile is important because domicile plays a part in determining how an estate is taxed. Now, everybody is born with something called a domicile of origin. And your domicile of origin is normally that of your father when you're born, if your parents were married, or if they weren't married, or if your father were to die before you were born, then it would be the domicile of your mother at that time. Your domicile can change and does change for many individuals. So certainly when you're a minor, if your father or your mother, if that's applicable to your situation, if their domicile changes, then your domicile will change with it whilst you're under 16. That's known as a domicile of dependency. There's also something called a domicile of choice. So it is possible to almost abandon your domicile of origin and create a domicile of choice. A typical example here would be perhaps someone that was born here with parents British, always lived here all their life, and then they decide to move to America and create a new life there. They buy property there, they work there, their family are there, they take all their personal belongings, they vote there, all their hobbies, everything, their whole life moves over there. They might well still hold assets here, such as a property to stay in when they visit. Perhaps they come over to visit extended family, but predominantly their life has moved over to America. At that point, you could say that they have established a domicile of choice. They've effectively abandoned that domicile of origin to create a new one. Whether you've created a domicile of choice is based on fact. So you would have to look at the individual circumstances as at the date of death. With deemed domicile, which is the other one I've put onto the slide there, in this country, you would be deemed domiciled here for inheritance tax purposes if you have been here for 15 of the last 20 years. So if you've been here for at least 15 years of the last 20, then you would be deemed to be domiciled here. So why is domicile important? So domicile is important for inheritance tax purposes. If you are domiciled here in this country, you will be taxed on your worldwide estate. So that will be all of your assets, so here and elsewhere. Whereas if you're not domiciled here, then you will only be taxed here on your assets in this country. So there is a big difference. So that is why it's important to establish what the domicile is of the deceased individual is as at the date they died. It is possible that with taxes, you can sometimes end up being taxed on assets in more than one country, but there is something called double taxation relief, which we have with sort of like a treaty with some other countries. There is only a limited number so that you're not double taxed. There is also something called unilateral relief, where HMRC do account for taxes paid elsewhere as well. I'm not going to go into that on this webinar, but those things do exist. The important thing to say about domicile is that the rules are going to be changing. So the domicile rules are often called the non-dom rules, but they're going to be changing to a residence-based test in April 2025. So rather than looking at, deemed domicile, domicile of origin, etc., what they're going to look at is whether you're a long-term resident, and you will be deemed a long-term resident if you've been here for 10 of the last 20 years. In addition, if you do become a long-term resident and then you leave the country, you would not immediately lose your long-term resident status. So, for example, if you'd lived here as a long-term resident for between 10 and 13 of the last 20 years, it will be 3 years before you would lose your long-term resident status. And if you're a long-term resident or you have that status, you will be taxed on your worldwide estate. Equally, if you've been here for 14 of the last 20 years, then it'll be 4 years if you leave the country before you will lose your long-term resident status, and only at that point then be taxed only on your assets here in this country. The new rules coming in are quite complex. They're not the subject of this webinar, but I just wanted to raise that the domicile rules are going to change come April next year, and hopefully we'll be able to provide a webinar on those at some point before they come in next year. So now on to succession. We've obviously just spoken about domicile, which determines whether your worldwide estate is taxed to UK inheritance tax or whether it's just your assets here in England and Wales. In the UK, we have something called testamentary freedom, which basically means you can make a will and you can decide who inherits your estate. Now, in some cases, people do not make a will and therefore they die what we call intestate, and their assets pass in accordance with the intestacy rules here. So the intestacy rules set out who inherits from your estate depending on who you're survived by. So quite often it'll be surviving spouse or surviving spouse and children, but it could be other members of the family if you do not have either of those. With regards to assets passing where you do not have a will, where you've got assets overseas, the general rule is that if you have immovable assets, so that's like property or land, these generally pass in accordance with the succession rules in the country in which that immovable asset is located. So if you've got a property, for example, in America, then probably the property will pass in accordance with the succession rules in America, where there's no will. If you have movable assets, so that's things like bank accounts, they tend to pass in accordance with the domicile of the person who's passed away. So if you were domiciled in America, using the same example, then the bank accounts would pass in accordance with the rules over there, even if you were living here at the date you passed away, or even if the bank account was located here, it would still generally pass in accordance with their rules. That is just the general rule of thumb over here and how we would treat those assets. One thing just to note, as I've put on the slide, some countries do have something called forced heirship rules, which dictate who inherits assets from a particular estate. I've put a few countries on there who have forced heirship rules, but these are just a few, but there are lots of countries that do have them. So with forced heirship rules, they basically dictate who should inherit within that country. And even if you made, for example, a worldwide will here, you may well find that in those countries they do not accept it. But it does vary from country to country. Who inherits under succession rules, or who inherits from a will, does have a bearing on your inheritance tax position, particularly in this country, because here we have the spouse exemption, for example, so assets passing to a spouse are generally exempt from inheritance tax. The only restriction on that is if if the deceased was a UK domiciled and their assets are passing to a spouse who's not domiciled here. In that situation, the spouse exemption is limited currently to 325,000. But if assets pass from a non-domiciled person to a domiciled person here, or if you're both, for example, domiciled here, then it would be unlimited. So succession is important in determining the inheritance tax position. Inheritance tax wise, different, as I've touched on before, different countries have different inheritance tax rules. And where you have a connection to more than one country, you do need to consider the different rules in the different jurisdictions. Some countries don't have any inheritance tax at all. So countries like Hong Kong, for example, don't have any inheritance tax. Others have a much higher threshold than what we have here. So here we have 325,000 of tax-free exemption. So that's called our nil rate BAM. But some countries like America, for example, their estate duty threshold is a lot higher. It's something like $13.9 million. So it's substantially different to what we have here. Even if there isn't inheritance tax to pay, it's still important to review all the different rules, because sometimes there is still reporting into the jurisdictions, even if there's no tax to pay. Administering a cross-border estate. On this slide, I've just put a few things just to think about. So normally if you have a will in multiple countries, or you're dealing with an estate in multiple countries, it is worthwhile having a lawyer in each of those jurisdictions, or somebody qualified to act within that jurisdiction acting, just because they know the rules and what needs to be done, because it is often different in every jurisdiction. Quite often where we deal with cross-border estates, we will act as a single point of contact. So we'll liaise with the lawyers overseas, and everything would go through us, which just helps everything run that little bit more smoothly. I've put on there, it's possible if you obtain a grant of probate, for example, here, or a letters of administration. So that's a grant of probate where you don't have a will, it's just a different name for it. But it's possible in 70 jurisdictions to actually reseal the grant over in their probate court. So rather than having to get and make a separate application, it's what they call reseal. So it's put through their own court system, and then it's recognised. The UK grant is recognised over there. It's often more straightforward, it's quicker, and often more cost effective. Cross-border estates, they can be complex. They're not straightforward. They can be time consuming. Lots of jurisdictions take a lot longer than we do here to deal with things. So they can take a long time, and they can be extremely complex, as I said, with particularly if there's no will, and working out, domicile, working out succession. Have they got movable assets? Have they got immovable assets? And where do they pass? So it is important just to get the correct advice. And then just finishing with a little bit about best practice. If you have a cross-border estate, it is best practice, to have a will that's tailored to deal with your cross-border assets. And in most cases, we would advise you have a will in each jurisdiction where you hold those assets. It just makes everything that little bit easier when you pass away. So we do normally advise clients to seek advice from lawyers with expertise in the relevant jurisdiction where they hold assets. It also might be an idea to seek advice, whilst you're alive. If anyone's watching this, they've got a cross-border estate, but they're still alive, it may be worth seeking some advice on your domicile position, soon-to-be residence status, and your likely inheritance tax position, to see if any steps need to be taken. For example, sometimes if people have moved abroad and they've tried to establish a new domicile of choice, but it isn't completely clear cut, the clients may ask us to provide something called a domicile statement, which is our opinion as lawyers on what we consider their domicile to be, which can be submitted to HMRC in the event of their death, to hopefully demonstrate to HMRC that they're not domiciled here and therefore only taxable on their UK assets. If you're an executor, I know I've said it a few times already, but it's really important just to seek professional advice in relation to the inheritance tax position and the succession rules to ensure that you get it correct. Same if you're acting in your position as administrator, if there is no will, you want to ensure that the correct taxes are paid in the correct jurisdictions, and that the estate is administered to the correct beneficiaries. So that's really all I want to sort of cover today. It's just an overview of the things that need to be considered if you're dealing with a cross-border estate, and if you are dealing with one and you're unsure, it is best to book an appointment and come in and see us, and we can run through things with you. But does anyone have any questions at this point? If no one has any questions, I've put my details here on the slide. So if you would like some advice from us, please do get in contact, and we'd be glad to assist. Many thanks. Thank you.